Oh, thank you, Mary. I will put you on the roster. Okay, hopefully. Oh, I got a couple more people. Let me see who else just came in so I don't miss anyone else. Check, 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 check. Mary. Okay, I think I have everyone. Cool. Okay. Today, I want to talk about legal research and what legal research is. Legal research is the investigation for information necessary to support legal decision making. It's the work we do to figure out what we can or can't do under the law in order to address questions that are raised by clients or others who have concerns or problems. In order to do this investigation for information, we need to know what the law is. And it brings us to the term sources of law. The reality is that in a legal sense, the term sources of law applies not only to, well, it has three different meanings. The term sources can mean the origins of the legal concepts, or it can mean the governmental institutions that formulate the rules, or it can mean the published manifestations of the law. And which meaning is applicable depends very specifically on the circumstances in which you are discussing as to which actual definition applies. When we talk about sources of law and we're referring to the origins of the legal concepts and ideas, I would note that legal concepts and ideas can have their origins in custom, tradition, principles of morality, economic, political, philosophical, or religious thought. In those situations, your legal research may extend to where did the ideas come from if you're looking historically at a particular law, or you're trying to understand more fully the policy reasons behind the particular law. In those circumstances, you may want to look at the source of the law, that is, the origins of how the law came to be. The most common use of the term sources of law is who wrote the law. That is, what governmental institution formulated the legal rules that you're discussing or looking for. In this country, that refers to the three branches of the federal government: the executive, legislative, and judicial. It refers to the 50 autonomous state governments with their three branches of government. It refers to the local government of the District of Columbia and all of the entities that come from those entities. All of these entities make law, and you have to understand the types of information created by each of these legal entities, as that helps you to know where to look for the particular types of materials you are interested in researching. And so the term source of law refers many, many times to who wrote the law. That is, which governmental institution is responsible for the law that is being discussed and utilized. Finally, source of law can refer to the where do you find it. That is, the published manifestations of the law. The term published used to mean printed. In today's usage, the word published means disseminated for general use. That means a published manifestation of the law can be a book, or it can be a database. It can be a microfilm, microform, optical disc, CD-ROM, DVD, any other type of media that includes legal information. So any published manifestation of the law, recognizing that published means disseminated for general use. Please note that disseminated for general use does not mean free. It just means accessible. So we have, for example, computer-assisted legal research databases that are all fee-for-usage-based services. You either pay by the search or you pay by the month for access to those services. Likewise, we have books that you have access to if you purchase the book, or you go to a library that has purchased the book and access it for usage. So just because there's a cost involved with accessing the information doesn't change the fact that it is disseminated, published, disseminated for general use. It just means that there is a fee associated with the ability to access that material for general use. We then need to understand the nature of legal authority. Here again, the law uses more than one definition for the term. That is, the term authority refers to two things. It refers to both the type of information and the degree of persuasiveness of that information. There are two types of legal information, two types of legal authorities. We have primary authorities and we have secondary authorities. Primary authorities are authorized statements of law by governmental institutions. These include case law, that is, case reports, written opinions of individual courts. We have constitutions, we have legislation, that's the statutes and codes created by the legislature. We have rules of court, rules, regulations, and opinions of administrative agencies, executive orders. All of these are dispositive statements of the law by the government, authorized statements of law by governmental institutions. Please note that it doesn't matter who prints the book. Case opinions are going to be primary whether the book is published by the government or the book is published by a private publisher. Whether you access the case report from a court's website or from a computer-assisted legal research database. So where you locate it, how it is published, does not impact whether it is primary or secondary. What determines the primacy of the material is who wrote the content. If the content was written by the government as an authorized statement of law by the government, it is considered to be a primary source, a primary authority. Secondary authorities are statements about the law which are used to explain, interpret, develop, locate, or update primary authorities. These would include treatises, articles in law reviews and other scholarly journals, American Law Report annotations, restatements of law, loose leaf services, legal encyclopedias. These are all authorities that are published with the intent to give commentary on the law. That is, to explain, interpret, develop, locate, or update those primary authorities. The term authority not only applies to what type of authority, that is, whether it is primary or secondary, it also pertains to the degree of persuasiveness of that authority. That is, the estimation of the power of the information to influence a legal decision. Some authorities are binding or mandatory, and others are merely persuasive. A binding authority is one where a court or other decision-making body believes that the authority applies to the situation before it, and that law is required to be followed. It is mandatory that you follow it. It is binding. Note that only primary authorities may be binding, but not all primary authorities are binding under all circumstances. A decision of the Texas Supreme Court is binding on all state courts in Texas, but it's not binding on a federal court, even a federal court in Texas. And it's certainly not binding on an Oklahoma state court. The federal court in Texas or the Oklahoma state court might find that this particular primary authority from the Texas Supreme Court is persuasive, and they may choose to follow it, but they are not required to follow it because it is not binding upon them. What makes an authority binding has to do with the extent to which the entity issuing the authority has jurisdiction over the entity determining whether or not they're going to apply that authority. When the U.S. Supreme Court speaks, everyone listens. Anything the Supreme Court has to say is binding on all federal courts and on all state courts. And that binding nature is even binding as to the Supreme Court, unless they can show a reason for distinguishing it. Other matters, secondary sources are only ever persuasive. Some of those secondary authorities are very persuasive, and their line of reasoning may be adopted by a court, at which point what the court had to say about that opinion or about that viewpoint makes it binding, as the court has stated it. But those secondary authorities are only ever persuasive, some to a greater and some to a lesser degree. Just because something is primary does not automatically make it binding. That is, as I said, many primary authorities are merely persuasive in the circumstances and the situations where they are being utilized. So the term authority relates to both the type of material and the degree to which it can influence the decision-making process. We have in this country a common law tradition of developing law. The common law was a body of law that originated and developed in England and spread to those countries that England settled or controlled. Common law jurisdictions include not only the United States and Great Britain, but also include Canada and India and Australia, other places where England settled and brought their system of law. This is contrasted with the civil law tradition that predominates on the European continent and in Latin America, especially those countries that were settled by continental European nations. So continental Europe would be France, Italy, Spain, Germany, Portugal, etc. They follow what we call the civil law tradition. Under the civil law tradition, there is a presumption that every legal question can be answered from the code. That is, there is a statutorily, legislatively enacted code, comprehensive code, and that code will be the answer to every question of law that might arise. Under the common law tradition, there is no such presumption, and courts are free to make legal rules to determine what the rule of law should be in those areas where the statutory law is silent, which is many, many areas. In this country, the federal courts are common law courts, and 49 of the 50 state courts are common law courts. There is one state that has a civil law tradition, and that would be Louisiana. In Louisiana, they follow the civil law tradition. And so if you are intending to work in Louisiana, I highly recommend that when you move to Louisiana, you do take a class in Louisiana state law, because how the law works in Louisiana is significantly different from how it works in the common law areas. And so the rules are significantly different and can make a difference in how you work in the field. And so since it is so different from what you will be learning here, I do recommend, if for some reason you find yourself working or wanting to work in Louisiana, do take a Louisiana state law class. Guam and Puerto Rico, to my knowledge, are also common law areas. I know Puerto Rico applies the common law. My understanding is that is the case also in Guam. Guam has only federal courts, and all of the federal courts are common law jurisdictions. Puerto Rico has its own set of courts, but they operate under the same rules as ours do. They have both federal and local courts in Puerto Rico, and so they are also part of the common law tradition. In order to understand how the common law has developed, it's important to understand the structure of the court system. On federal and state levels, we have hierarchical judicial systems under which certain courts have jurisdiction and control over other courts. In general, there are 3 levels of courts: trial courts, intermediate appellate courts, and highest courts. And different types of information is generated at each of these levels. Trial courts are at the bottom. These are the courts of original jurisdiction. These are the courts where you actually try cases. Parties file pleadings and motions. These are courts that actually hear testimony, see witnesses, review facts, render judgments. These are the courts that conduct jury trials. Most of these courts issue judgments rather than written opinions. Where the court does issue a written opinion, they are not published except under rare circumstances, and they do not serve as precedent, only as information. So district court opinions are not binding on anyone. They are merely informational. On the federal side, the trial courts are U.S. district courts, and we have hundreds of district court judges throughout the country. Most states have one or more judicial districts. Texas has 4 federal district court districts. They're divided north, south, east, west, but their delineation, that is, their borders, are not quite as simple or clear as they might otherwise sound from the directional nature. Texas has 4 districts. Dallas and Fort Worth are in the northern district of Texas. We'll get to which Court of Appeals circuit they're in a moment. But Texas of itself has 4 district court districts. In your Legal Research Illustrated book, on page 60, there's a diagram of the geographic boundaries of the U.S. Courts of Appeals and the U.S. District Courts, so you can get a sense of how the district courts are divided up in Texas. We will also be talking about this when we get to that chapter in the book, so we'll go over that in more detail in the future. But on the federal side, at the bottom, you have the U.S. District Courts. On the state side, we actually have 3 levels of trial courts. At the lowest level, hearing the more minor cases, we have Justice of the Peace Courts and Municipal Courts. These are courts of very limited jurisdiction. They hear the most minor criminal matters, and the Justice of the Peace Courts hear small claims, while the municipal courts also hear violations of municipal ordinances, code violations, and things of that nature. One step up from there, we have constitutional and statutory county courts. They handle a little bit higher level civil matters, and they handle Class A and Class B misdemeanors. So still a misdemeanor court, but these are misdemeanors that can carry jail time with them. And then the most serious civil and criminal matters are heard by Texas district courts. District courts have unlimited jurisdiction, as well as jurisdiction in terms of mounting controversy and jurisdiction over all felony matters. In the middle, you have your intermediate appellate courts. On the federal side, these are the U.S. Courts of Appeals. These courts have jurisdiction over trial courts in specified geographic areas. They do not hear evidence or review factual matters. Appellate courts review claimed errors of law reflected in the record created by the lower court, and they issue written opinions that are often published and then available to research. The intermediate appellate courts in the federal system are the U.S. Courts of Appeals. There are 13 of these, 12 geographic circuits, and the U.S. Court of Appeals for the Federal Circuit. The first 11 of those circuits serve a minimum of 3 states or territories. The 12th is the District of Columbia Circuit, which serves the District of Columbia only. And then we have the U.S. Court of Appeals for the Federal Circuit that hears appeals of specialized matters, especially copyright, patent, trademark issues. A lot of intellectual property appeals go to the U.S. Court of Appeals for the Federal Circuit. Texas is in the Fifth Circuit for the U.S. Court of Appeals. The U.S. Court of Appeals for the Fifth Circuit serves Texas, Louisiana, and Mississippi, and it sits in New Orleans. In general, the Court of Appeals sits in a principal city within the circuit. In this case, they sit in New Orleans because it is perceived to be the largest city most centrally located. When Katrina was headed toward New Orleans, the Fifth Circuit Court of Appeals picked up and moved, and they moved to Houston to be able to reconstitute the court and to continue to hear matters. As it turned out, their evacuation plan to Houston was not their best choice, in that giving up one coastal city for another almost coastal city did not bode well when a number of alphabet letter storms later, Hurricane Rita bore down on Houston about 6 or 7 weeks after Katrina hit New Orleans. It was the best. So my understanding is that the current plan, if another hurricane should be headed toward New Orleans that requires evacuation, that the court would evacuate to Dallas rather than to Houston in the future, so as to be more inland and out of the way of the high impact of a hurricane or tropical storm. At least they learn. In this case, Laura, which made landfall today, was initially targeted, they thought, at Galveston and Houston, but it wobbled and it actually hit Louisiana, somewhere between Port Arthur and Lake Charles. That's what I was thinking. So Texas got lucky to the detriment of Louisiana. And the storm track is going to go east and northward over the eastern part of the United States, but it should miss Oklahoma and everything north of Oklahoma, and even some things east of there like Missouri and Iowa, which is good because Iowa already had a pretty devastating storm. Getting the remains of a hurricane would not have been the best thing for them, considering that they're still having power outages and such. So we have to work around the weather around here. Some of the circuits are larger, some of the circuits are smaller in geographic area. The largest circuit is the Ninth Circuit, which sits in San Francisco. The Ninth Circuit includes, let's see if I can read this, Alaska, Hawaii, Guam, the Mariana Islands, Arizona, California, Nevada, Idaho, Oregon, Washington, and Montana. That's a lot of states. So it is the largest of our courts of appeals. The smallest one is the District of Columbia Circuit, which serves only the District of Columbia. Those are the intermediate appellate courts. Courts whose cases are appealed to the intermediate appellate court must mandatorily follow the decisions of that court. So if you're in a U.S. District Court in Texas and the Fifth Circuit Court of Appeals has issued an opinion in a case with similar facts, your court will need to follow and to apply the precedent from that Fifth Circuit case. If, however, the Fifth Circuit is silent, they haven't heard a case like this, but there is, for example, a U.S. Court of Appeals opinion on similar facts from the Ninth Circuit, the U.S. District Court may choose to follow what the Ninth Circuit did or do something else that's what they've decided to do, or if some other circuit has a differing opinion, they might choose to apply what that other court had done. None of them are binding because it is not the court to which the U.S. district courts in Texas refer the cases. At some point, if the case goes up to the U.S. Supreme Court and the U.S. Supreme Court rules, that decision will be binding on everyone, since that is your highest court. On the state side, we have the Texas Courts of Appeals. There are 14 Texas Courts of Appeals. And they also serve geographic regions. There are 2 Texas Courts of Appeals in Houston, the 1st and the 14th District. The 2nd Court of Appeals is in Fort Worth. The 3rd is in Austin, 4th San Antonio, 5th Dallas, 6th Texarkana, 7th Amarillo, 8th El Paso, 9 Beaumont, 10 Waco, 11 Eastland, 12 Tyler, 13 Corpus Christi, and then the 14th is back in Houston. If you have a case that's heard by a Texas District Court in Fort Worth, that appeal would go to the 2nd Court of Appeals that sits in Fort Worth. In addition, the Fort Worth Court of Appeals hears cases appealed from other counties in the surrounding area, including Parker County, etc. A trial court in the 2nd Court of Appeals, so a trial court, for example, sitting in Fort Worth, would be required to follow a decision of the 2nd Court of Appeals, but they would not be required to follow a decision of, for example, the 5th Court of Appeals over in Dallas. They could choose to be persuaded by it, but they are not required to follow it. At the highest level, you have your courts of last resort. On the federal side, that court of last resort is the U.S. Supreme Court. On the state side, we have 2 highest courts. We have divided the jurisdiction between civil and criminal matters, and as such, the highest court for criminal matters is the Court of Criminal Appeals, and the highest court for civil matters is the Texas Supreme Court. When either of those courts speak, all of the other state courts in the state must listen. Now, the Supreme Court doesn't talk to the Court of Criminal Appeals and vice versa, and they don't have any jurisdiction over each other's matters. But all of the lower courts, that is, all 14 intermediate courts of appeals, that is Texas Courts of Appeals, and all of the Texas trial courts, be they justice courts, municipal courts, county courts, constitutional or statutory, or district courts, must mandatorily apply decisions of either of those 2 highest courts. There are some matters all of these courts have primary authority. A court is a primary authority in that opinions that they issue are dispositive statements of law by the government. So case opinions are always primary authority regardless of who publishes the book, because this is the statement by the judicial branch of the government as to what the law is pertaining to a particular subject matter. Once you understand the hierarchy of the courts, it is then necessary to understand our tradition under the common law of following precedent. It's important to note that there are matters where state courts have exclusive jurisdiction and some matters over which federal courts have exclusive jurisdiction, and then there are matters where there's concurrent jurisdiction. That is, you can file in either federal or state court. However, once you have picked a forum, once you're in state court, you have to stay within the state court hierarchy. If you're in federal court, you stay within the federal court hierarchy. That is, if you didn't like what the U.S. District Court did, you don't appeal it to the state court of appeals, you have to appeal it to the Fifth Circuit. Once you're in a jurisdiction, you have to stay within the hierarchy of that jurisdiction. Under the doctrine of following precedent, the decision of a common law court settles not only a dispute between the parties involved in that dispute, but also sets a precedent to be followed in future cases regarding other litigants where the matter in controversy is the same or similar. When a prior precedent is applied to current problems, courts make law. There are three Latin terms that pertain to this doctrine of following precedent that I want you to be familiar with. And while they are in your chapter, since I'm going to talk about them individually, I'm going to type the three terms into the chat so that you see how to spell the words that I am speaking about. I think it will make it a little bit easier to understand. So the three terms that you need to know about when discussing the doctrine of following precedent are stare decisis, ratio decidendi, and dictum, sometimes known as obiter dictum. Stare decisis is a Latin phrase meaning to stand on things decided, and stand on what has been previously decided. The decision of a court is binding authority on the court that issued the decision and on all of the lower courts within the same jurisdiction for disposition of factually similar controversies. This question of whether a decision of a court is binding on itself actually came up in this term of the U.S. Supreme Court. In the June medical decisions that were decided in the early part of July, the Supreme Court was considering whether a Louisiana law dealing with requirements for practitioners in abortion clinics was or was not constitutional. In this case, the Supreme Court found that the law in Louisiana was unconstitutional. Four of the justices found it was just strictly unconstitutional, period. The fifth justice that made up the majority was Chief Justice Roberts, and he wrote an opinion that said that the Louisiana law was unconstitutional because it was so factually similar, that is, similar on its face, to the Texas law that had been previously found to be unconstitutional a few years ago in a decision by the U.S. Supreme Court, that the doctrine of stare decisis required the court to find that just as the Texas statute was unconstitutional, so too is the Louisiana statute. What made this an interesting decision and opinion was that Chief Justice Roberts filed the dissenting opinion in the Texas case. That is, he disagreed as a matter of law that the law was unconstitutional. But the majority ruled that it was unconstitutional. So he thought the law was constitutional, and the court said it was not. But now he said that since this law was identical to, or virtually identical to, the law that had been previously invalidated, that the court was bound by the doctrine of stare decisis to find the Louisiana state law also unconstitutional, because it wasn't any different from the law that had been previously ruled to be unconstitutional. And stare decisis required that the Supreme Court apply its own precedent and follow its own precedent. Obviously, the other 4 justices disagreed with his review of how the law works, but his vote plus the 4 other justices who felt that it was unconstitutional did provide a majority. With regard to stare decisis and the doctrine of following precedent, the ratio decidendi is the holding or the principle of law on which the case itself was decided. The ratio decidendi is the determination made by the court that sets the precedent and is binding on courts in the future. Courts in this country do not state general propositions of law, nor do they answer hypothetical questions. Courts in this country decide actual cases and controversies and announce rules that are tied to specific fact situations. As a result, a precedent or a ratio decidendi must be considered with the facts of the new case in determining whether you need to apply that precedent, the old precedent, to the new case. And that's the factor that caught Chief Justice Roberts in the Russo versus June medical case, which was that because the Louisiana law was almost word for word identical to the Texas law that was found unconstitutional, there was no way to differentiate the facts. There was no distinction in the facts that would justify a different result. And so, having already ruled that a law with that wording was unconstitutional, the court needed to uphold its own decision making since nothing else had changed, and therefore follow its prior precedent. Finally, when you file an appeal in a case, it is not uncommon to appeal that case on a number of points of error. That is, to point to several different mistakes that the court made that might justify an alternate result, overturning the previous result and sending it back for a new trial, for example. When you file an appeal, it's not enough to say, we should have won. That is not grounds for an appeal. The only way to appeal a case is if you can point to specific decisions made by the trial court, that is, rulings of law made by the trial court that impacted the outcome of the case and may have caused an erroneous result. That is grounds to file an appeal. Let me give you an example. There's a lawsuit in Dallas, and during they seated a jury's impaneled, they seat the jury hears the case. Among the evidence that is presented that the jury is listening to is some evidence that is highly prejudicial. That is, it has the potential to inflame the jury, to make them angry and excited and upset about something. And the probative value, that is what the evidence was used to prove, is very low. It doesn't really prove anything, but it is highly inflammatory. And the evidence is, the prosecution goes to put on this evidence, and the defense objects to the evidence being put on, and the court overrules the objection and allows the evidence to be presented. And then later at the trial, the defense tries to put on evidence, and the prosecution objects, and the judge disallows that evidence. And the defense goes ahead and puts on the record outside the presence of the jury an offer of proof. That is, they put on the record the testimony that would have been presented should the court have allowed the request. On appeal, the defense files different bases for the appeal. They appeal on the basis that the judge allowed evidence that should not have been allowed. They appeal on the basis that the judge didn't allow evidence that they should have allowed. And as it turns out, one of the members of the jury who served on the jury in Dallas County didn't live in Dallas County. That juror lived on a street in Grand Prairie where half the street is in Dallas County and half the street is in Tarrant County, and he got summoned by the wrong county. The computer thought, because of the number of the address, that the house was on the Dallas County side, not the Tarrant County side, but because it was a cul-de-sac, the numbers were such that in reality the house itself was in Tarrant County, so the person on the jury should not have been allowed to serve on the jury. When the Court of Appeals hears that case, they're going to review all of the points of error, but they're generally going to rule based on one. The one that they would most likely rule on would be the improper composition of the jury. That is, if the jury was improperly constituted, there was somebody on the jury who was not eligible to serve on the jury, they would have to reverse the case and send it back for a new proceeding with a jury composed of individuals who were able to serve on a jury in Dallas County. Excuse me. That would be the ratio decidendi. That is the point of law on which the case turns. That's the actual precedent. You can't have a jury that is not made up of members, all of whom are eligible to serve in the county. However, the court may choose to address the other points of error that were raised. And so they might say, oh, and by the way, if we had gotten to these other points of error, we would have found that it was also error to allow this evidence that was so prejudicial and didn't have any real probative value. And we would have found that the judge should have allowed the defense to put on the evidence that was not allowed, because we reviewed it and it didn't meet the reason for which it was objected, and they should have been allowed to do that. That, oh, by the way, if we'd gotten to these other points, this is what we would have done language, is not ratio decidendi. It is not precedent. It's what we call dictum or obiter dictum. That is not binding. That is not a precedent that is binding on anyone. However, especially where the case is reversed and remanded for new proceedings, that oh, by the way language is very persuasive to that trial judge as sort of coming attractions. That is, you're going to get another bite at this apple. You're going to get to retry this case. Don't make these same mistakes again. So you're going to constitute the jury correctly, but you also don't want to make the same mistakes about allowing or not allowing evidence that the Court of Appeals says you made the last time, because if you do the trial exactly the way you did it the last time, but you fix the jury problem, you get the same verdict and it goes back up on appeal, it's very, very likely that that same court of appeals is going to reverse you again, saying, we told you, by the way, this is what we would do if we got to this. You put the evidence on or didn't put the evidence on the same way, so we're going to reverse you because you shouldn't have done it this way. That dictum is highly persuasive, especially in the same case, but can also be highly persuasive to other courts within the same jurisdiction for similar cases where you don't have the jury constitution problem. So we like to say that yesterday's dictum may be tomorrow's ratio decidendi. In other words, oh, by the way, the extra language from yesterday may be the basis on which and the precedent that the court sets in the next case, or in this case when it goes up again in the future. And so it's a really good idea to notice and recognize dictum when you see it. And even though it's merely persuasive, to know that especially within the same jurisdiction, it can be very highly persuasive in determining what is likely to happen into the future. Courts do have significant leeway in interpreting precedent. For one thing, it's very rare that you're going to get exactly the same fact situation presented in court. The Russo versus June Medical was a really unusual case in that the law that was being sued on was almost word for word identical to the previous law that had already been found to be unconstitutional. That doesn't happen a lot. Usually what happens is they try to accomplish those same results, but using different words or different actions to try to get to the same place, so then they can distinguish, well, we didn't use those words. We didn't do it that way. And so that can make a difference in how you look at things in total. Part of the process in making decisions and in applying precedent involves determining whether the precedent itself applies, whether the difference in the facts should prompt a different result. A court can reject a binding authority and do something different if they find an ability to significantly distinguish between the facts of the two cases. That is, the case that's in front of them versus the case that was previously decided. Oftentimes the court will look at who made the prior decision. Was it unanimous? Who wrote the opinion? Things of that nature. But they're going to start with how different is this case from the original case, because how that difference is interpreted will have a direct effect on whether they can distinguish sufficiently to result in a differing outcome. When cases go up on appeal, most commonly, the determining factor of whether or not the court committed error has to do with, did they know there was a mistake or a potential mistake there, and did the court take steps less than calling for a mistrial to try to remedy whatever the mistake was that occurred. And so sometimes even something that would have been reversible error based on precedent can be diffused or not be considered to be potential reversible error, but simply what they call harmless error, because the court actively took steps to try to mitigate the result. Let me give you an example. A while ago, more than a decade ago now, in Houston, a woman named Andrea Yates drowned her 5 children. At the trial, she pled not guilty by reason of insanity. Now, this woman had a long history of major depression with psychotic features that started after the birth of her first child. In fact, her postpartum depression was so severe and required hospitalization, and she and her husband were suggested not to have any more children. Please note that at the time she drowned all of her children, there were 5 of them. So after the first, they were told, don't have any more kids, and they ignored that 4 more times. Each time, while she was pregnant, it put her depression in abeyance, but each time after the delivery, it got worse. It was a very sad case. To compound it, she had 5 children under the age of 8 who she drowned, who she was homeschooling because she and her husband had decided, or her husband had decided, that it was too dangerous for the children to be educated in the public schools because of their particular religious beliefs. At the trial, where she had pled not guilty by reason of insanity, both sides put on significant testimony about her mental illness. And on rebuttal, so we've had the experts for the defense in support of her claim of the fact, yes, this was in Houston, the claim that she was not guilty by reason of insanity. On rebuttal, the prosecution called several witnesses, one of whom was a psychiatrist from California. And he testified that in addition to having reviewed her records, he had been told that the defendant, Andrea Yates, was an avid fan of Law and Order. She was not just a fan, she watched every episode and every version of Law and Order. So she watched Law and Order and Law and Order SVU and Law and Order Criminal Intent, and she watched all of it religiously. And he testified that he had been a consultant on a script for Law and Order, and that in that script, a woman killed her children and then claimed she was not guilty by reason of insanity. And he believed she was copycatting what she had seen in the show. Now, his original report didn't have anything to do, didn't say anything about this Law and Order theory. And so the defense was surprised and was not given enough time to research it before they were required to rest their case in the trial. While the jury was deliberating, the defense went out and hunted down the production company for Law and Order and found out that yes, the psychiatrist had consulted on a script, but that after he had put his stamp on it and said yes, psychologically it was sound, they decided not to film it. Since they never filmed it, they never aired it. Since they never aired it, Andrea Yates could not have seen the episode. And so even though the jury was deliberating, the defense came back and asked the judge to declare a mistrial because the jury had heard testimony that while all of what they heard was true, the supposition of the psychiatrist was erroneous. He was just wrong. He assumed something that didn't turn out to be real. The judge denied the motion for a mistrial, claiming that this was a rebuttal witness and it was bolstering testimony, and they had heard testimony and it didn't really make that much difference. Then the defense asked for what we call a curative instruction. That's where the judge brings the jury back in and they instruct the jury what to not consider. They tell the jury that something they heard turned out not to be right and that it should not form the basis of their decision. Once again, the judge denied the motion on the basis that this was bolstering testimony. The jury came back and found her guilty. On appeal, they brought up these issues, and the Court of Appeals ruled that this was reversible error, that if there had been a curative instruction, it would not have been error. But since the judge denied both the mistrial and the curative instruction, that they had to overturn the case and send it back for a new trial. In the new trial, and there was a further trial, she was found not guilty by reason of insanity. The judge believed that because this was just one more drop of evidence, when there was lots of other evidence, that it didn't have that much influence. But the Court of Appeals said because the judge did not take steps to correct the erroneous impression left with the jury pertaining to her mental status, that the case had to be overturned. On new trial, they didn't call that witness from California. There was no testimony about law and order, and the jury found that she was, in fact, not guilty by reason of insanity. The saddest part of that case is that Andrea Yates will never get out of jail. I mean, she's not in jail. She's in a mental hospital, but she will never get out of a secured facility mental hospital. When she takes her medication that makes the voices that told her to give her children to God go away, she can't live with herself because she knows what she did. And when she doesn't take the medication, she is completely psychotic. What actually happened that precipitated what occurred is she had been in an inpatient mental health facility for 3 or 4 weeks immediately prior to when she killed her children. And she had a new doctor, and that new doctor decided that her real problem was that she was taking too much medication. So they took her off her antipsychotic medication. They took her off the medication that was making the voices go away, that she had been hearing for years. And then she ran out of insurance, and they sent her home without finding out what happened. And then she was at home 3 days post inpatient psychiatric treatment, and she was homeschooling 5 children. His mother, her husband's mother, was supposed to come help her with the children that morning, but she was running late. The psychotic voices told her that the only way to protect and save her children was to give them to God. And she thought that the voices she was hearing were God and God's angels. Yeah, everybody failed. The doctor failed. Her husband failed. The family failed. It was a failure of epic proportion. The saddest thing to me is she's in the hospital forever. Those children are dead. And her husband has remarried and has more children. He was never held in any way accountable or responsible for anything that occurred because he theoretically did not violate any laws. It's pretty messed up. No question. Yes, he did become an attorney. Um, it's a crazy situation. Okay, we have hit the point where I ended in my other two classes this week in the Monday, Wednesday, and the Tuesday, Thursday morning classes. So I am going to stop here for today, and we will talk about legislation and the interpretation of statutes next Tuesday. Please, for next week, read the remainder of Chapter 1, and you can begin reading Chapter 2. If your research book has not yet come in, and I know there are research books out there and they're not that expensive because I've been on multiple websites, so that is out there. If your research book has not come in, I do have a scan of the second chapter of the research book. So if you need that, if you will email me, I will send you. If you don't have Chapter 1, I'll send you Chapter 1. If you don't have Chapter 2 and you need it, I will send you Chapter 2. I am not going to get to those tonight. This is the end of my fourth class for the day, and I haven't had supper yet, so I'm going to eat supper, and I will not be doing emails this evening, but in between meetings tomorrow, I will get chapters sent out for people who request